Good morning, everyone. As Radhika said, that the previous session gave us a lot to think about, and this will give us a lot to debate about. Not just debate on stage, but I think often you ask yourself many of these questions and wonder which side of that debate you are on. So let's start with perhaps what's on our mind when it comes to the country's courts. Are we a country of progressive laws with poor execution, or are we a country of a lot of laws still finding their feet? I'll start with you, Gopal.
I think it's very difficult to say whether the laws are progressive or not. What we do know is that we do try to regulate almost every arena of human action, and this allows politicians of different hues to be selective in what they regulate. They regulate what they wish to regulate. They choose not to regulate what they don't want to regulate and allow it to be ad hoc. So I feel, especially if I'm looking at, say, the last 15, 20 years, there has been a change from what I believe are welfare legislations like the right to education, the right to information, the Rehabilitation Resettlement Law, which repealed the Land Acquisition Act, many environmental legislations. I've seen that not being something that's been carried forward. I would have hoped administrations would carry that forward. And I've seen possibly a harsher hue with reference to civil liberties, personal liberty particularly. The Enforcement Directorate and its powers under the Prevention of Money Laundering Act. Many amendments that have been made since then. I haven't, if you had to ask me, would I find a welfare legislation? I wouldn't find one in the last 10 years. But I would find perhaps things like this Uniform Civil Code in Chhattisgarh, PMLA and how it's been operated elsewhere in the country. I'd find many of those, which takes care of small little, contingents of people and their interests. But if something is available to the entire country, I don't really find that with reference to health and education and things like that.
So, Saurabh, what's new about law being interpreted the way people would like it to? And also, what's new about politics using the law to suit their interests? Unpack this for me based on what Gopal said.
Well, look, I think law and politics are intimately connected. They have to be, right? Law is really about how society should be regulated, and politics is a way to bring that about. So that synergy that exists between law and politics is inevitable, in fact necessary. That's why we have politics. That's why we have law. They don't independently exist with a truth of their own. Law has no inner morality to itself, other than we can discuss that. But generally, no. It's just how should society be organized and reflected. So that, of course, is a fact that there will always be a correlation between politics and law. And if the law follows the politics of the majority at a particular time, then the politics of the minority will always think the law is a tool for oppression. So there is then a tension between law and politics, not innately otherwise, which exists, but because a certain person believes.
Are those the times we're living in?
Well, we've always lived in those times, because politics will always differ. We live in a country of 1.4 billion people. We can't all think the same. Neither should we, right? Consensus and all is well and good, but we don't want uniformity either. So as long as differences exist, it's inevitable that law will favor one or the other side. The way we see in court every day, there are decisions taken one way or the other. There will be winners, there will be losers. And that's how law and politics intertwines. The question is, are there certain, and I now contradict myself by saying that law in itself has no inner morality. Maybe that is, as a social tool, probably correct. But as a society, we have certain morals, I think, which are encapsulated in our constitution. There, I say, politics and law have to work together to fulfill those ideas, which are mentioned in our fundamental rights chapters, in our ideas of socialism, secularism, etc. Now there, politics and law must work together to fulfill ideas which are otherwise unwavering and should be fixed.
So, you did mention that laws don't have and inherent morality. But if one looks at the last few years, the courts have taken decisions or come up with rulings that have possibly reflected more of the public sentiment and sort of broken into this notion that, yeah, the courts are watching. And there are times that the judiciary has seen, seem to have come across as more progressive than even public discourse. Now, unpack that with some examples for us and also talk to us, why do you think that is the sign of our times? Where it looks like courts are very powerful at the moment.
Look, I think to say that in the recent years, the courts have been interventionist when they haven't in the past. If you leave the history of India from 1950 to about 70 aside, I think from the 70s, there was an interventionist era in Indian judiciary. And they've been interventionist ever since. And as long as interventions have carried out, there has been criticism. Multiple people, whoever have suffered, typically governments, decisions of the courts have called out the government, the judiciary, for being excessively interventionist. So I don't think it's true in the last few years the courts have been interventionist. I would say it's the reverse. If anything, in the last few years, the courts have been a little less interventionist than they have been in the past. To the extent that when there are a few notable exceptions, then they make headlines because there are notable exceptions. Now that could be because those judgments needed to be given. I'm not necessarily making a comment. But I think there is a general tendency to believe, and I'll call out one particular judgment, the way Gopal also mentioned the PMLA, and we can talk about the PMLA, how that was upheld by the courts. Now that's hardly an interventionist action on the part of the judiciary. The role of the judiciary ultimately has to be to protect the fundamental rights of its citizens. It's not to do politics. It's not to make other decisions for the country. The role of the court is ultimately to safeguard every individual citizen of the country. Okay. And when it does so, it's not being interventionist. It's only doing its job, which is to do that.
I know in part you read out the book to us, but I want Gopal to poke this a little bit because you talked about timing and you talked about, the many times that the courts, are doing their job. We're talking about a time when the last 15 days we've had UCC make headlines, we've had electoral bonds make headlines. Can we really say that courts and timing is not a matter of coincidence?
See, as a lawyer practicing in the courts, I think we are much closer to what's actually happening in the courts. So to reduce it to a question of, oh, the court is playing ball with the government or the court is interventionist, I think is meant for Twitter and social media. It's meant for people who are not getting nuanced and getting close to it. Let me tell you the factors that play a role in any case. And let me tell you the quantum of the workload as well. In the Supreme Court, for example, we have 16 courtrooms functioning on any given day. We have, on Mondays and Fridays, close to 1,000 cases being heard. 1,000, right? Heard and disposed of on Mondays and Fridays, which are our miscellaneous days. Now, nobody is discussing those 1,000 cases. They're discussing the 3 or 4 cases which the media decides to highlight. Yeah. So electoral bonds is decided on the same day as, say, 30 other cases. Electoral bonds grabs the headlines because of what it deals with. Yeah. But the other 29 cases don't have a political hue attached to it or media flavor, so you don't talk about it. Now, in a particular litigation, strategy of lawyers is important. I was in the Kashmir case, for example, arguing against the manner of imposition of 370, right? I know that as petitioners, our strategy was terrible. We had counsels who had not prepared, who addressed the court. We know that when questions were put by the judges, uninformed, unread counsels were giving answers which were stupid as far as our strategy were concerned. Judges make up their minds based on that. Now, the person, just give me a minute. So the person reading the newspaper the next day, when the judgment comes out, says, oh, this is bound to happen. It's a right versus left thing. It's a Modi government versus an anti-Modi government thing. It's not that. It's actually a suture going wrong in a surgery can mean the difference between life and death. Yeah. That's what it is. So the art of advocacy and the role it plays with how well prepared you are, how well you present your case, how you strategize is very important. So electoral bonds could have easily gone the other way if the strategy was bad, if the arguing was bad, if the advocates are not up to it.
Yeah.
So when you reduce it just to, achha, they're playing ball with the government or they're not playing ball with the government, I think you make it a very basic kind of debate, which it's not. It's actually very, very
But
forensic.
public goes by perception.
Yes.
And perhaps one would say in the last couple of years, you know, where democracy might have left people unsatiated, courts have risen to the occasion with timely news headlines like this one.
No, yeah, but let's take an example of those who are, for example, Omar Khalid, his bail application for 3 years, the petition was pending before the Supreme Court, and every 3 weeks people would talk about the fact, oh, look at this poor guy, he's stuck in jail and nobody's doing anything about it. His lawyers allowed this matter to drag on for 3 years. Bail SLPs normally are disposed of in the Supreme Court very soon, 2-3 months. But you keep taking adjournments for 3 years, and then what happens 2 weeks ago, you withdraw the petition. Now, then don't blame the courts. I'm saying the courts do deserve blame. I'm not a huge advocate for everything that the courts do. They make as many mistakes as everybody else does, right? But don't keep on attacking the courts when, as an arm of the government dispensing justice, arm of the state dispensing justice, what the courts do is that in 95% of the cases, they're dealing with cases which are under the radar, but it's some poor man's pension, it's somebody's land dispute, somebody's consumer issue, which they're sorting out. They're doing all that. On these occasions, yes, obviously, I mean, in many of these cases, we would have expected the courts to be tougher. But the judges of the Supreme Court are a reflection of the people of this country, right? Every time you see a car accident happen and somebody lying on the street, you'll find 95 Indians standing around taking videos of it. One guy will be trying to help that chap. So that's the ratio of people in the judiciary as much as it is in parliament or anywhere else.
Okay, I'm going to just shorten this and ask you very directly. On a scale of 1 to 10, where are you on the electoral bonds decision?
I think it's 8.5.
Okay. So,
well, since no one's going to challenge me on this, if I say 9, does that matter? The question is, it's a good judgment, right? Numbers don't make a difference. I suppose the nuance for numbers between 9 and 8.5 will make a difference to constitutional lawyers like Gopal, and because a lot of what a judgment decides is also speaking to the future, right? So the reasoning and the rationale of the judgment is why we will give numbers. It makes little difference to an average person on the street. Other than the fact that they feel that the court today has said that an average citizen has the right to know where there is an interplay between politics, finance, and corporates. The fact that corporates and politicians are in bed with each other, I think doesn't come as a surprise to anybody. That's always been the case, not just in India, across the world. In fact, it is inevitably so, right? The problem is, if there is a quid pro quo, which there will be, at least the public has the right to know about it. People may say that the average person on the street doesn't really care about this knowledge. Why are we so hung up upon it? I think that's to undermine the intelligence and the intellect of the person on the street. They know very well as to who's in bed with whom. Second, as I said, you're speaking to the future. The future generations will find this information. It will be digested by the media, which a lot of you here are, and will then be presented to the public. And therefore, the right to know that has been espoused in the electoral bonds case is what would make it a 9. It would have been 9.5, I suppose, if it had come 2 years earlier.
I would in fact...
So you're saying timing does matter?
Of course it does.
And so does it pay a price for transparency? I mean, you know, I know this prima facie, this is a transparency effort.
Yes.
But has it come too late?
It's only partly, if I may, it's only partly a transparency effort. Why I said 8.5 and why I didn't say 10 is because of this. Once the Supreme Court of India says something is illegal, right? What you normally do is set aside the illegality. That's not been done. All you've said is, this electoral bonds is bad, put up the details of all the money you took. Now, if it was completely illegal, you should direct each of these political parties to return the money. That's where you take it all the way to 10. But you didn't do that. You stopped short. So for me, it's a 3/4 measure, and we're very relieved that it's a 3/4 measure. But eventually, you're allowing each of these parties, particularly the BJP, who is admittedly the lion's share of this, to get its 10,000, 20,000, 100,000 crores and spend it. Now, if it's illegal, make them return it.
Look, you were talking about timing, Shelley, and let me just take an example of something that deeply concerns the media. Matters of defamation and what is called the muzzling of the press by all political parties. We have multiple judgments by our courts upholding the right of free speech. The right to press is one of our most fundamental rights. But that matters little when you get arrested in a small town in UP, Bihar, Maharashtra, and you're in custody for a long, long time, months. You know, we think a month is not a long time. Even a few hours of custody for any of you, or even 1 day's custody, will mean a lot. Yeah. And the court will ultimately give a judgment saying that, oh, this is a violation of free speech, this should never have happened. But in the meanwhile, you've been in jail for a month. You are going to remember that. And next time when you're speaking out, we'll keep a bit more muted. Not only you, but all your colleagues in the media will say, well, this guy or this woman went to jail for a month. Maybe it's my turn next. So as long as the media is not protected immediately by the courts, yeah, and that's what timing matters, it ceases to have meaning. You know, we often say in law that operation successful, patient dead. So you have a great lengthy judgment coming out, but if there's no substantive relief which is given immediately, it renders the judgment often meaningless.
Okay, let's just talk about the other news piece that will remain around for debate as more and more states look at the Uniform Civil Code. We always debate this, and I think this is not new, but it's very relevant today that whether social change comes before the law or the law comes before social change. My question to you is slightly different. Should law be involved in social change in the way it is in the Uniform Civil Code? The example of Uttarakhand, where we are, we're coming down to details of how live-in partners should declare to whatever is the nearest, system of registration. And, the kind of details that just question adult behavior and choice.
Look, there are two separate facets to what you have just said. What is the connection between law and social change, and then the content of the law, right? I think we should keep these two questions separate. Law, as I said, is nothing other than society. So to say what business does law have to interfere in society is misconceived, with the greatest respect. Because after all, the idea of marriage, which is a societal construct, is regulated by law. So law permits marriage, unless you are gay. But if you are straight, then it regulates marriage. Law regulates every aspect of society. From where you drive, I mean, you asked earlier about are we over-legislating and under-regulating? Well, look at Indian roads for that. Answer is yes. But to come back to the question about whether law and society are interrelated, obviously, right? Law is a way to enforce rules that society has decided need to be adopted. Law is nothing but a system of rules. So obviously law and how society is governed are connected. That doesn't mean we can't comment on the content of that law or the decision society has taken. You gave the example of the Uttarakhand Civil Code. I personally believe, and I know probably Gopal does as well, that it is necessary for the country some 75 years after its existence to have a uniform civil code. It's imperative. We cannot have differences of different laws because they typically end up being gender unjust. Yes. But there is a lot to be said about how you bring about the law, right? It's not just the end that matters, it's the journey. So I think there is a lot to be said about how the UCC in Uttarakhand has been drafted and is being now brought in. Rather than by consensus bringing people together, from a top-down approach, there's a problem, I think, which also then engenders feelings of mistrust. Yeah. We live in polarized times already. Why not try to bring everybody together? I mean, there was a consultative process, but it was really not very consultative. But you identified the one weakness in the UCC of Uttarakhand is this live-in relationship concept. Now, I cannot for the life of me understand what was going on in the mind of the draftspersons. As you said, it's not law yet. What were they thinking of when they decided that this live-in relationship should be mandatorily registered? without defining what a live-in relationship is.
So, we all think about laws and courts as our safety nets. And I'm beginning to wonder, keep going back to this point around morality that Saurav talked about a little while ago. Isn't this, in a way, throwing a bait around the idea of what morality is, and the courts are center and front with it on the UCC, for example?
Well, unfortunately, morality is used in the Constitution as a control. It's used in Article 19, it's used in Article 25 with reference to religious institutions and freedom of religion, etc.
Just hold the mic closer.
Yeah, as a ground to restrict the operation of any of these rights. Now, I think the problem with that, and that's what we saw in the 377 judgment, is that you have to show on what basis you are making a law for a particular purpose. The UCC, for example, in Uttarakhand and elsewhere, and this debate has always been posited as a debate effectively, as far as the public is concerned, that look, you had a Hindu code which came in the 50s, and you did nothing to ensure that Muslims, Christians, etc. would be on par. I mean, we have the Christian Marriage Act, but with reference to Muslims particularly, you've allowed them to run riot with having 4 marriages, etc. There's a broad idea behind the debate on UCC. But if you are a lawmaker making the Uniform Civil Code, you must realize that the divisions in our community are not only gender, sexual orientation, for example. If you have a uniform civil code, just ensure that any kind of alliance, regardless of sexual orientation, is also covered by the UCC. The Uttarakhand Civil Code deals with marriages and deals with live-in relationships. The definition of both is man and woman, but not man and man, not man and... So for me, that's a problem. You've had this issue coming up again and again. You've said that the LGBTQ community should not be treated as criminals. The next logical step is to allow them the rights that the Constitution affords them. I believe the Supreme Court bucked the opportunity and passed the buck to the Parliament when this issue came up. Saurabh argued also before that bench. This was the perfect opportunity for you to take care of that issue as well. Take care of it regardless of community, regardless of gender, regardless of social orientation, sexual orientation, regardless of caste. All those issues should have been covered. So I think morality is something which is undefinable because each political group at that point of time in Parliament, having the numbers, will claim that what we are saying is moral. The courts will interpret that and decide at some point of time that it is or it is not. It took us from 1860 till 2019 for us to finally have this judgment come which struck 377 down. In fact, in the present penal code, as well as the proposed new penal codes that they're bringing in, there is a provision, a shocking one, in the penal codes which exist even today, which says that if a man entices a woman, I don't know how you entice women, but you entice a woman out of a marriage, then that man is guilty of an offense. The man is guilty. The woman is just an object to be moved from point A to point B. How do we have these provisions in law even today? How is it that when you have a standing committee and Parliament says yes to this, what are these guys doing? They've taken an oath to uphold the Constitution. 543 of them are voting on this, and all of them say, okay, champ, let's go, this is a good law. You had this opportunity now. I mean, do these guys even read the Constitution? It shocks me that you pass laws like this, continuing to treat women as chattel after all these years.
You see, just again to come back to this old chestnut between morality and the law. When the Frank Sinatra song about love and marriage which go together like a horse and carriage. Morality and the law is something similar, really. Because at one point, the morality of the society must be reflected in its laws. Otherwise, people will simply not follow the law. If there is a whole series of immoral laws, as we saw in Nazi Germany, of course, they followed it there. But generally, the idea is your laws should be conformed to the morality of a society for ensuring its observance. At the same time, you need to protect people from morality. Because that same morality of society can, in instances, become oppressive. So a morality of a majority, when it dictates to a minority that you must eat this, you must dress this way, you must live in a particular manner, this is whom you can or cannot love, that is when morality starts becoming oppressive, and you need protection of the courts from that morality. Yes. And yet the Constitution talks of that morality that Gopal talked about. which is what the courts have said, that the morality we talk about is what is called constitutional as opposed to popular morality. The idea or the values of the Constitution, the idea of dignity, the idea of freedom, the idea that people are able to love and live the way they want to, that is the morality that the courts should intervene. That doesn't mean that Parliament has no role.
I hear so much disappointment in your voice as you say that, because you are clearly feeling that the courts could take that stance, but they're not.
Well, I'm a lawyer. I'm always disappointed, but also optimistic. Disappointed because I saw most recently the judgment of the marriage equality case that was delivered, that Gopal referred to. The judges did not merely buck the trend. I think they actively hid under a rock and said, sorry, this is not for us. Let someone else do it. Yes, we see the violation of fundamental rights. Yes, we have taken a constitutional oath of office to uphold, preserve, and protect people, but we will not do anything about it. Thank you very much. Best of luck for the future. Okay. That's what the court said. Optimistic because they have been these 5 judges, 3 of whom who ducked the issue. I see today hope in the young of this country. I see hope in the high court judges that one goes around and interacts with and argues before across the country, that they will be more receptive to the positive change that this country is seeing and needs. So a mix of both.
I'm going to again pick a statement you said, disappointed but optimistic. Is this how you feel about waiting for your appointment to come through?
I would remove the optimism in that part.
Gopal?
I would.
I
Can I
hope
use the
you're
word
optimistic
realistic
on his
instead?
behalf.
Well, look, I have a different view about judges and their appointments, etc. I personally would never accept what I think is an unforgiving job. For Saurabh as a friend, I hope it doesn't come through. For Saurabh as an excellent lawyer, and I believe who would be an excellent judge, it's better for the institution if it does come through. Touching upon that disappointment that he mentioned, Saurabh is not sharing the fact that the disappointment, apart from being an advocate, is deeply personal for him, right? He's got a same-sex spouse. He's been waiting years for the recognition in this country. Yeah. He's won it bravely, and he's withstood years and years of criticism and gossip and everything for what he's done. And I find it awful that my country and my institution, the judiciary that I serve, wasn't able to take care of Saurabh and his kin. And I hope that someday, it's all very well to say fraternity in the preamble of our constitution, but my problem, especially with politics today and the media today, is that we try to divide everything down the middle. It's this or that. It's Modi, not Modi. It's Supreme Court, not Supreme Court. We don't try to find the common ground where we can take care of everybody and just try and look for common ground and everything. I just hope one day the court will take care of the interests of Saurabh and his kin.
Yeah, our obsession with binaries. Yep. Okay, so just to come back to a couple of other important subjects like the ones that we've so far discussed is, of course, the whole question of whether we should rethink the words in our constitution. Dr. Swami's plea, the words secular and social. Where are you on that? And please feel free to sort of display candor in your answer.
Well, if you speak of nuance, I'd straight away distinguish the socialist and the secular. The insertion of the word secular in our constitution was at the same time meaningless because it is already a secular constitution. Yet, at the same time, a matter of great importance because it reminds people that we are a secular constitution. Words matter. Words mean things. When you use a word, it conveys an idea. It's all well and good to say that we don't need the word secular in the Constitution because it is secular. We all agree it is. But when the preamble of the Constitution, the basic text, the first few words you read of the Constitution tells you you are a secular Constitution, it puts a balm on the minorities of this country saying, yes, we live in a place that respects us, that values our existence. So I think the retention of the word secular in our preamble is imperative. Socialism, on the other hand, is something that I have my differences with. Partly because our constitution is not a socialist document. We have the right to do business and have our free trade and profession. We have a truncated form of a right to property. We live in a country which has, after 1990s, shed the path of socialism. We require political parties to make an oath of office saying that I will affirm to the values of our constitution. And yet that party may be avowedly capitalist, and it should be. That's part of free speech, right? So to dictate a particular form of economic philosophy, which the constitution itself does not necessarily mandate, there I have a problem with. But I don't think it's for the court to strike down these words that were added.
I have a slightly different view on this. Initially in 1950, our preamble didn't have the words secular and socialist. It doesn't mean that we were not a secular country until the 70s when this amendment was brought into the constitution. The issue on which the Supreme Court has entertained Swami's plea is a very narrow one. It's only that, look, can you insert something in the preamble with a backdate? Can you say that the preamble, when all the Constituent Assembly members sat together, our founding fathers, and said, this is our preamble, can you now, ex post facto, after many of them are dead and gone, attribute to them 2 words which they didn't put in the Constitution? In my view, secular is superfluous because it's there in the Constitution. Whether your preamble said it or not, it's a secular Constitution. I don't think there's a doubt about it. Yeah. Socialism, in fact, should never have been inserted in the Constitution, either pre or past, and I'll tell you why. Because under the Representation of People Act, where parties are registered, Section 29A requires that you say as a political party that I am going to be socialist, secular, etc., etc. Yeah. If you don't say that you're going to be socialist, you're not allowed to be registered as a political party in this country. And that's bizarre. If a capitalist political party interested only in profit wants to register itself, you can't participate in this democracy. So for me, I believe that, yes, let's not meddle with the preamble. I don't think you should ever have made amendments to it in the future, because think of what could happen now. Suppose next year they amend the Constitution to bring in 3-4 words which are unpalatable to you. You've already set the trend saying, yeah, we can do it.
We can do it. Fair. Okay.
Are you saying, just one last line, are you saying political parties are not capitalist?
Good point. Okay, I know that lawyers are not people of few words, but I'm going to force the two of you to literally take one phrase, sort of tests on this one. One law that should be done away with in India?
The PMLA.
Okay, you?
Income tax.
Income tax. Oh my God. Look at that. The CEOs all woke up just now. All right. The one law that should be there in India?
A generic anti-discrimination law which protects rights of minorities, women, scheduled castes, sexual minorities, everybody.
Okay.
In the same vein, a Civil Rights Act which takes care of all communities. The Supreme Court Judge Antonin Scalia of the US came and criticized India for not having that law after the March on Washington. The fact that we never got one and we still don't have one. So at a private space, you can discriminate on caste and stuff and nobody can do anything about it.
Yeah, okay. And this is the hardest question. Keep it short. What is your idea of India?
Well, I'll keep it short, rather like myself. The idea of India to me is already embodied in our constitution. The idea that I can be different, yet feel Indian. The idea that I can express myself in whichever way I want without someone else calling me out and saying, hey, you, because you live in that way, you are not Indian. The right to my dignity, the right to my freedom, the right to my choice belongs with me and me alone.
Yeah, go back.
Fraternity.
Include brotherhood and sisterhood since I'm here. Thank you very much, both of you.
Ideas of India. Yeah, ideas of India. ABP Network's Ideas of India.